Rosie, can you hear me now? I hope so. This is Nancy, and I apologize for that before when Greg muted when I came online. I could hear a lot of crackling when he was speaking as well, and so I am hoping that you will now have a better time hearing the audio.
That's great, Lisa. Thank you so much.
That's great. Okay, so fortunately, you're missing most of the introductory remarks, which are not as important as the rest. You've had a chance to look at this screen now, this slide, so I'm going to move on and pick up the pace. All right. One of the overviews in terms of increasing drug use around the US is that we are seeing a lot more positivity rates by industry sector. And so whoever is on the call, you are probably seeing an increase in the number of individuals testing positive. And I hear as an attorney that there are a lot more employees who are just coming to work impaired. And when, I don't know if the right word is confronted, but when they're asked to sit down with their manager or boss or human resources department to ask about their behavior, many of them are simply admitting that they have in fact recently engaged in drug use. And this is, of course, a huge problem for managing the business and ensuring that people are coming to work well. Now, I want to talk a little bit about marijuana as treatment, because you may have read or heard something about, marijuana as a remedy for opioid abuse and something better than opioid abuse. And you may also have heard that marijuana can be assistive in managing chronic pain. Intriguingly, a lot of people who have signed up for medical marijuana around the state of New Jersey and indeed around the country will say that chronic pain is their issue. And what's interesting is that marijuana doesn't actually make the pain go away, but it may make you mind it a little bit less. And what's really interesting is that small amounts of THC, which is the psychoactive ingredient in marijuana, coupled with small amounts of morphine, are not very successful at managing pain unless you use them together. So this is a result of some, the science, where the science going is marijuana coupled with opioids, in fact, may be more effective at addressing pain and less dangerous than opioids alone. And if you are an employment law lawyer like I am, the big question that begs is, what about the workplace? Are you kidding me? We're going to be medicating people now with opioids and marijuana together, and what might the effects of that approach be? We don't know, but what we do know is we're going to be dealing with it more and more. So let's talk a little bit about marijuana law. I want to give you an overview of federal law, and you'll hear me call marijuana pretty much throughout the presentation. All marijuana is a form of cannabis, but not all cannabis is marijuana, as I'll explain as we get into that, and that is why I choose to use the term marijuana about what we're talking about today. Although cannabis is, I understand, sometimes a preferred terminology for people who use marijuana medicinally. All right, so federal law, by the way, continues to prohibit the use of marijuana, the possession of marijuana, and it's also placed on Schedule 1 of the Federal Controlled Substances Act, and that means that it is a drug with little or no medicinal value and a high likelihood of abuse. The DEA chooses where to place marijuana on that schedule. There are, of course, lots of studies suggesting that marijuana can have some medicinal effects. Unfortunately, NIDA, which is the National Institute on Drug Abuse, and the research arm of the government, seems to be concluding that it also can have some long-term deleterious effects on the brain, on cognition, and even on IQ. And that is, I think, what is making the federal government, among other things, reluctant to simply reclassify marijuana. But the point of being on Schedule 1 is you cannot get a prescription for medical marijuana use. And I have put a couple of cases there that you can look up later if you're interested. Those basically stand for the proposition that, yes, Congress has the right to regulate marijuana to make it unlawful if they wish to do so, and they have the power under the Constitution to do that regardless of what the states would like to do. There's also the Federal Drug-Free Workplace Act. This was passed back in 1988, and it requires federal contractors to provide, or at least attempt to provide, a drug-free workplace. That would include barring the use of marijuana in the workplace. A lot of employers think they have federal contracts and they are covered by this Drug-Free Workplace Act, who may in fact not be. If you receive a grant in any amount from the feds, then yes, you are covered by the Drug-Free Workplace Act. But if you have a contract, it's really only contracts for services, not goods that the feds could go out and buy on Amazon if they chose not to go to you directly, or some other retailer, of course. And it's only contracts that are above the simplified acquisition threshold. That was $25,000 back in 1988 when the law was passed, but it is currently $250,000. So, and if you're a subcontractor, that doesn't count at all. So that's what the Drug-Free Workplace Act requires. The Americans with Disabilities Act, which does protect individuals who are alcoholics or who are drug users in recovery, does not protect employees against adverse action on the basis of disability when the employer actually is relying on the fact that the individual has used an illegal drug. And so because marijuana remains an illegal drug under the Controlled Substances Act, it is perfectly lawful as a matter of federal law to take adverse action, i.e. decline to hire or fire or refuse to put someone in a safety sensitive role, for example, on the basis of their medical marijuana use. So no federal law. And I'll add, because it's worth noting, that you cannot get a prescription for marijuana. There are a few prescription medications that contain THC, and we'll cover those a little bit later, but what people get when they use marijuana medicinally is a recommendation or a certification from their physician. They can't get a prescription. If a doctor writes a prescription for marijuana, he or she could have their license to prescribe revoked. So what people get is not on a par from a legal perspective with an actual prescription medication at this time. So that's the overlay of the federal law. There's also U.S. Department of Transportation regulations and other federal regulations that require drug testing of your employees. For example, Nuclear Regulatory Commission, some Homeland Security contracts with the Army or the Navy, for example, may include drug testing provisions. But the most common federal contract law or federal law that covers private sector employers is the Department of Transportation regulations, and they do require drug and alcohol testing. Marijuana use of any kind is prohibited for these regulated workers, and that includes CBD products. The Federal Motor Carrier Safety Administration, which covers over-the-road drivers. Other operating administrations falling under DOT would include, for example, Federal Railroad, FAA, pilots, et cetera. But FMCSA is the biggest, and they make it very clear, even if you're not subject to federal drug and alcohol testing regulations, if you're subject to the medical qualification standards for drivers, marijuana use is totally prohibited. So as you move forward, you may find yourself having some workers who are covered by these federal rules and for whom you must not permit marijuana use, even if authorized by the state of New Jersey. And for others, you may have difficulty telling the worker that you will not continue to hire or employ them because they use marijuana in accordance with the laws of the state of New Jersey. So it's a complicated regulatory system we're setting up where federal and state law are clearly in conflict, and that means you end up treating employees differently under the law. And one final thought on marijuana and drug use in general in New Jersey. There is about the same amount of illegal drug use going on in New Jersey right now as there is in any other jurisdiction across the United States. And so that's just a zip code map of where people test positive and in what percentages. And I suppose if you want to feel pretty good, the darker green is worse. So Maryland to the left and just below there is not looking as good, and nor is Connecticut. All right, so let's talk about the state medical marijuana initiatives. As you know, New Jersey's not alone in this, right? There are medical marijuana laws started in California and Arizona and kind of rolled their way east. And what's interesting is these were laws that were designed to accommodate individuals who were having really significant medical conditions. California, as I mentioned, was one of the first. Colorado followed, and Oregon, Washington added medical marijuana laws. And then of the states listed up there, you'll know California, Colorado, Michigan, Oregon, and Washington also permit recreational marijuana use. But what's interesting is none of these laws were conceived as employment related. In California today, if I am a medical marijuana patient, my employer can choose to turn me away, to terminate my employment. And that is true, of course, if I'm a recreational marijuana user as well. So each of the states listed there had a state Supreme Court case, with the exception of Michigan, there was a federal court case there. And that state Supreme Court said, there are no protections for medical marijuana users under our law. And the California case went so far as to say, even if the voters had attempted to pass a law that would allow for some employment law protections, California, acting alone, cannot actually change the status of federal law. So what's happened in these jurisdictions is employers that care about marijuana use may test and may have rules prohibiting marijuana use both at work and away from work. Or if they are in industries where safety perhaps is not so much a concern, or philosophically they are not opposed to the use of marijuana for recreational purposes, they will not test, or they will permit the use, they will hire people who use marijuana and they don't get into it. So where we are on these West Coast states, and with a couple of, Michigan there in the middle, is that sort of the market is deciding whether marijuana use will be permitted or tolerated. And in each of these cases, federal or state law controlled the outcome. In July 2017, Massachusetts elected to go the other way. The Massachusetts medical marijuana law is 100% silent on employment, but the state Supreme Judicial Court ruled that marijuana users who were approved to use marijuana as a matter of state law in a medical program should be protected under Massachusetts law against discrimination. It's not called that in Massachusetts, it's called Chapter 151B. But that was the first of the nation, the first state Supreme Court to hold that marijuana users might be entitled to some work protection. Well, since that time, a lot of states have adopted similar legislation, and some of them have been around a while, but are only getting fleshed out. This is, to the best of my knowledge, the list of states that currently have statutory protections for workers using medical marijuana. These are all different. If you have any operations outside New Jersey, we're not going to go into that today, but I will tell you that the law in Arizona is not the same as the law in Delaware, is not the same as the law in Illinois, and is not the same as the law in New Jersey. So if you're a multi-state employer, there's a lot of different things that seem to be happening. One trend is that in Nevada, in New York, and in Massachusetts, which is not a statute, but a case, as I mentioned, they treat medical marijuana users as potentially entitled to reasonable accommodations of their disabilities, including their medical marijuana use, as a matter of state disability law. In other states like Oklahoma and Arizona, there are specific carve-outs in the law that allow employers to decline to place medical marijuana users in safety-sensitive roles. And in a few states like Rhode Island, Connecticut, and now New Jersey, the law is a little bit more equivocal and will say that you can't take adverse action against medical marijuana users solely because of their marijuana use. And we're going to get into what that means for you. You are surrounded by other states that have permitted some protections for medical marijuana use. All right. So when medical marijuana first became a thing in New Jersey, the law was silent. It did not contain employment law protections, and it was not interpreted to include any based on some of the legislative history. Patients were, in fact, granted access to marijuana without fear of prosecution or adverse state action, but they didn't enjoy any employment law protection. The employer, in fact, had the discretion as whether to test at all or to excuse positive test results by marijuana patients. That all changed this summer. On July 2nd, your governor signed the Jake Honig Compassionate Use Act, which provides protections for medical marijuana patients where none existed before. That law took effect immediately. And here's the important language. Employers cannot take adverse employment action solely, because an individual is a registered qualifying medical cannabis patient. Okay? What does adverse action mean? That's sort of the standard. It's failing to hire someone, letting them go, making them retire, discriminating against them. And what is unclear is whether you could move them. Well, we will assume that moving someone to a different position within the organization would also be considered an adverse employment action, at least if they had different job duties and perhaps different benefits or compensation or things like that. Now, this law and the restrictions on what you can do with respect to employment don't apply if you would violate federal law, right, or have those contract implications as a result of those restrictions. But as we'll get into in a minute, that those federal protections may apply only to certain workers and not to all of the workers in your workplace. From a legal perspective, the lawyer looks at this and says, okay, what does it mean to take adverse employment action solely because someone is a registered qualifying medical cannabis patient? Does it mean that if you're a registered qualifying medical cannabis patient and you test positive for marijuana, we can take adverse action? Well, we'll discuss that in a minute, but I'm going to suggest that answer is probably not. If the only adverse if the only thing that the individual has done that violates your policy is test positive. Does it mean that you can take adverse action because an individual is a registered qualifying medical cannabis patient and the individual holds a safety-sensitive job? Maybe. Does it mean they were a registered qualifying medical cannabis patient and they came to work impaired? Probably. But these are the questions that are going to have to be answered on a case-by-case basis. And at this point, we don't have useful guidance from the government in the way of regulation or from the government through the court system in the way of an interpretation. So every time you have someone who is a medical cannabis patient in New Jersey, you have to take a look at this little blurb. Can we take adverse employment action? Do we wish to take adverse employment action? And what are the restrictions on that? What would our reasons be? Now, the law does allow you to continue to test for marijuana. It, however, adds changes to how your testing program may be run. And if you haven't updated your testing program now, it's important that you do so right away, because you may have had a testing program for the last couple of decades, and the only rules that sort of existed in New Jersey were sort of a set of best practices, if you will, that the New Jersey Supreme Court said they like to see dating back to 1991. We now have a statute that says if anyone at all, you don't know if they're a medical marijuana patient or not, if anyone at all tests positive for marijuana, you've got to go through this process. And that process is going to slow down your testing program, right? The first thing that you must do is provide written notice to the individual who has tested positive, letting them know you've got a right to offer a legitimate explanation, and it's got to be a medical explanation for that, okay, medical results. You may be doing this already through your medical review officer, but I have not worked with many employers that have a written notice policy where the notice comes from the employer, right? Not typically the MRO, advising the individual of their right to offer that response. You also have to include in that written notice of the individual's right to a confirmatory retest. again at the individual's expense, but that was never part of New Jersey law. It might have been a best practice, but a confirmatory retest has not been part of New Jersey law until now. And frankly, it only exists for marijuana positive results, although you may want to do that for others. And you have to include that in the written notice. Once the individual receives the written notice, and I believe the law is silent as to how you get that to them, but you might have to be able to prove that they did receive it. Once they receive that written notice, they have 3 days to respond. Responses that are identified in the statute as potentially helpful are the fact of an authorization for medical cannabis issued by a healthcare practitioner, or proof of registration with the New Jersey Cannabis Regulatory Commission, or both. Interestingly, you don't have to show that you've registered with the New Jersey Cannabis Regulatory Commission in order to have an authorization for medical cannabis use issued by a healthcare practitioner. I'm not certain why the difference, but I suspect it may have something to do with authorizations for medical cannabis issued from people who practice in other states. If I live in Pennsylvania and I'm authorized to use medical cannabis in Pennsylvania, but my job is in New Jersey, typically New Jersey law is the one that would apply. So this may make things a little more seamless. Now, let's say you have a person who tests positive and they give you both an authorization and a proof of registration. Their green card is what they call it these days. That does not mean you have to ignore the positive test result. At that point, you decide whether to take adverse action. And again, go ahead, decide whatever you want, but your decision had better not be based solely on the individual's marijuana use, unless you fall within one of those exceptions we talked about earlier. For example, this guy drives a commercial motor vehicle for us. Cannot excuse that here. So this is the process that you need to follow, and if you haven't done it already, I urge you to create a quick form or process to make sure people get those test results right away. Now, the old law also stated very explicitly, employers are not required to accommodate medical marijuana use in the workplace. And I know that anyone who is a Drugs Don't Work New Jersey member has already taken into heart that it's a great idea and you should continue to prohibit the use of marijuana, marijuana products, cannabis, whatever you want to call it, at work. That provision was repealed and there's a new provision. It now says you may prohibit, right, or take adverse action if someone possesses or uses intoxicating substances during work hours or on workplace premises outside of work hours. So it's a little bit different, but I think largely with the same effect. People generally do not need to be accommodated by permitting them to use marijuana or marijuana products during the workday, or immediately after the workday, immediately before the workday, on meal and rest break periods, premises that you control. It's okay to prohibit that, and I advise that you do. It is still illegal as a matter of federal law, and introducing marijuana and marijuana products into the workplace can lead to some unintended consequences. Now, I've told you all about the Honig compassionate use law. What about the New Jersey courts? Well, some of you may remember that back in April, the New Jersey Court of Appeals also ruled that medical marijuana users are entitled to accommodations under the law against discrimination. That was unexpected, but consistent, as I've mentioned, with the statute in New York and the case law in Massachusetts, saying that individuals who use marijuana may be considered disabled and entitled to protection under state law, not available to them under the Americans with Disabilities Act, the federal law. Interestingly, that case turned on a holding that said the employer acted unlawfully, even though there were earlier cases allowing adverse actions based on an employer's belief that the worker was engaged in illegal drug use. the case concluded that because marijuana was lawful for medicinal use under state law, the marijuana use was not illegal. And I find that there's tension in that holding, that the employer knew or should have known marijuana was now legal, and the earlier New Jersey precedent saying if the employer has good reason to believe the use is illegal, they can act on that, right? Because guess what, right? Marijuana is in fact still illegal as a matter of federal law. The employer is put in kind of untenable position. Which do you follow? Perhaps because of that, the New Jersey Supreme Court actually has agreed to review this case, and they're going to be issuing a decision probably not too far away, but we don't have an answer on that basis. What will be interesting, at this point, right, this case in some ways does the same thing that the new statute does, but there may be some clarity for employers as to whether they are allowed to take into consideration the fact that marijuana use is in fact illegal as a matter of federal law as they make decisions. There are certain roles, of course, within organizations where that tension might continue to exist. And I think, by the way, the manufacturers of Sour Patch Kids may have a trademark infringement action based on the photo that I've used here. You can buy that on eBay. All right. Now, some of you may be wondering, like, wait, state law is conflicting with federal law. Doesn't federal law preempt? Doesn't federal law control? What about all of those states that concluded that state law cannot, legislate where federal law says the opposite? How can a state require modification to a federal, regulatory scheme? And maybe just at the base, how do I comply with both state and federal law? This is an ongoing concern for employers, and I want to tell you that there is a case that gives us some insight. It is a Connecticut case. It's called Nofsinger, and this was a case in which the applicant was made an offer of employment and disclosed that she was likely to test positive. She said, I've got PTSD, I use medical marijuana, I'm going to test positive, and in fact she did. She had actually started employment, which usually makes it harder to walk that back, but she was let go, and she brought suit alleging that Connecticut's medical marijuana law protected her. And her employer said, no, state law is preempted by federal law, that Controlled Substances Act, the ADA, the Food, Drug, and Cosmetic Act, the Federal Drug-Free Workplace Act, they were a federal contractor, all of the statutes that I mentioned at the beginning of the webinar. And they also said, we didn't act on the basis of her status as a palliative use of marijuana act patient, but because she tested positive of marijuana. What is interesting about this Connecticut law, there's a couple interesting things about this. First, the Connecticut law, as you'll see in a minute, is almost identical in terms of the language to the New Jersey law. What happened here? The court said, action based on a positive workplace drug test for marijuana is in fact status-based discrimination when the employer knows the result was caused by marijuana use lawful under Connecticut law. In other words, a positive drug test alone, you would expect someone to test positive if they were a marijuana patient. The employer here acted solely because she was a marijuana patient. There was nothing else on which to turn. The court rejected the idea that the Federal Drug-Free Workplace Act prevented the employer from hiring this person because the Drug-Free Workplace Act prohibits only the use and possession of marijuana at work. And this marijuana patient said she didn't need it at work. She would use it at home in her off time. And the court granted summary judgment to plaintiff, which is very, very unusual. So you've got my takeaway there. Zero tolerance policies premised on federal law are under attack. What you need to know is this Connecticut statute is, again, very, very similar to the New Jersey statute, prohibiting people from turning away or taking adverse action against workers solely because of their use. The other thing that might catch your attention if you are familiar at all with how the court system works is, this wasn't a state court in Connecticut that ruled, hey, our Connecticut statute is good enough for you and everybody. This was the federal district court in Connecticut, which suggests that, in fact, there is some way for these federal and state statutes to work side by side. Now, I want to wrap up with a few ideas for you. Can we adopt an impairment-based standard is usually what I get next. If we cannot take the adverse action on this basis, what can we do? The first thing you should know is there's no way you're going to be able to tell whether your employees are using a lot of marijuana or too much marijuana. And the reason for that is that marijuana, and THC in particular, is really just not what it used to be. As you'll see from the slide, THC content in marijuana used to be quite low, 3 to 6%. In Colorado, which collects the marijuana from sale there from its laboratories and from its vendors and runs tests on them, the average THC, which is again the psychoactive ingredient, is more around 25%. But more than that, you are looking now at marijuana edibles, which have a range of potency. The serving size may be tiny, like 1 chocolate bar square, which I could never control myself to eat just one. But you're also having dabbing and marijuana oils and things like that will allow you to vape 90% plus THC. And patients use what they want to use when they want it. The programs simply tell the patients, use marijuana until you feel better. So there's no way to ask a physician, for example, to do some sort of fitness for duty evaluation, because they're not going to have any guidelines to understand how much marijuana the person is using or when. Okay, some states like New York do offer some low THC marijuana syrup, and those can be helpful if but there's no restriction in New Jersey on what someone uses, so you're not going to know. I put in some of the short and long-term effects here, and you'll see, most people will start feeling high right away if they smoke or vape, 30 minutes to an hour if they ingest in one of the edibles. You'll probably feel high for 3 to 6 hours, and then you won't feel high anymore, and you won't be high anymore, unfortunately. According to one of the medical review officers that I work with a lot, the better studies seem to suggest that decision-making and reaction time may be impaired for about 24 hours after use. So we are having some of those things. And then there's some long-term effects, as I mentioned earlier, that I think are causing the researchers to hesitate to make it just openly available, particularly to younger people. So how can we rely on supervisors to address perceived impairment and order reasonable suspicion tests? Well, here's a great use of your Drugs Don't Work New Jersey resources. You need training, and you need to document what you're seeing. You need to encourage supervisors to act when they see something. There is no New Jersey standard for how much marijuana is synonymous with impairment under the motor vehicle laws. And therefore, you're going to have to try and document potential concerns another way. Some of you may recall a couple of years ago, OSHA thought that they would tell employers, hey, no post-injury drug testing unless you can demonstrate impairment. And they were forced to walk that back because drug tests like alcohol tests don't measure impairment. They measure the amount of THC or alcohol in the individual system at that time. The alcohol and driving has been around a long time. We have a lot of studies that show that if you have a certain amount of alcohol in your system, you are likely to be impaired, but we don't have that for marijuana yet. And drug tests have different detection windows, right? When you do a breath alcohol test, you're measuring what is circulating in the individual system at that time. I see more employers who are either grappling with accommodating medical marijuana users or who work in states where recreational marijuana is a thing, switching from urine and hair drug tests, unless they're in highly regulated or safety-sensitive rules, to an oral fluids test, or in some cases even blood tests, to try and measure what is in the individual system at the time. And you'll see, if you use marijuana, that's the bottom of the graphic there, the THC metabolite, if you use it once or occasionally, it'll only stay in your system 1 to 3 days. But if you're a medical marijuana user and you use it habitually, even after you stop, marijuana may continue to be in your system with 30 days. The oral fluids tests say that they can only detect marijuana use that is circulating in your saliva and blood and for a period of less than 24 hours. So if you're trying to sort of hone in on whether someone is actually coming to work with enough marijuana in their system to render them impaired, that coupled with observations and concerns maybe helps you where urine drug tests would not be, particularly as you know that someone is going to be a chronic user if they're a patient. So it's something to think about. And you might think that because oral fluids tests can only detect marijuana use in the last 24 hours, they would detect fewer marijuana users than do urine tests. But interestingly, that doesn't seem to be the case. There's a lot of speculation over why that may be the case, but the fact that you cannot cheat an oral fluids drug test may be one of the reasons. As I mentioned, New Jersey does not have a marijuana cutoff level for determining when someone is driving under the influence. And in fact, you don't have any implied consent law to submit to marijuana testing on the request of law enforcement. You only have an implied consent law for breathalyzer, breath alcohol tests right now. So that may change, but you can see that some of the surrounding states do actually have different DUI standards. And interestingly, even though Delaware protects medical marijuana users from adverse employment action, if you have marijuana in your system, even if you've been legally entitled to use that drug, it's not a defense to a criminal action. So employers in Delaware, for example, have to think really carefully before they put someone behind the wheel, even driving their own vehicle around the state, if they know they may test positive if something goes wrong. So we are at about the 11:50 mark, and we promised to leave time for questions. So I am going to stop here and see if you have questions for me. I can also talk about CBD for a little while if you don't have questions, but I wanted to give you all a chance. So if you have some Q&A that you want to put up there now, or, raise your hand or put some out there, and we will answer some questions for you.
Thanks, Nancy. So I do have several questions that have been submitted, and I'm going to just basically read them verbatim to you right now. One of the first questions that came in was dealing with marijuana use in the workplace versus marijuana use at home. I think this is something you touched on when you were discussing the Connecticut court case. And just to clarify, is there a difference then if somebody uses marijuana at home and then comes to work the next day and declares that they've used marijuana and shows up, and it shows up in in some kind of test, blood test, urine test, that type of thing?
Yeah, so this is really where the active management is such an issue, right? So you can prohibit marijuana use at work and during the workday, and as I've mentioned, I think you pretty much should. There's no entitlement to come to work impaired, but how do you know if someone's impaired if they come to work the next day? I've mentioned the use of an oral fluids or possibly even a blood test to try and determine if someone is impaired at work, but you're not going to really be doing those typically unless someone has shown reasonable suspicion or perhaps has been involved in an accident. And then it may bolster, right, your conclusion that something was off, either because the person caused or contributed to an accident or because they were acting strangely, possibly smelling of marijuana. There's a couple problems with saying people are using it at home and are not coming to work impaired. The first is that the impairment may persist for longer than the person believes it to have. And actually, in New Jersey, one of the interesting things is that 1991 case I mentioned before that said, here's what we, the New Jersey Supreme Court, would like to see in a drug-free workplace program that includes testing. They wanted employers to warn individuals who used illegal drugs of the fact that the impairing effects could linger long after the person had believed them to wear off. So that part's interesting, and we'll have to see how it plays out. Right now, all I can say is a positive test by itself is probably not enough to demonstrate that someone came to work impaired. So we do want you to, document that test and/or perhaps, limit your testing. There's a difference between a pre-hire test where you're not actually suspicious that someone is impaired, or you most likely wouldn't make them an offer, and a reasonable suspicion or a post-accident test, which may be more focused and you can demonstrate that there was something besides the positive test that caused you to want to take action. And or, as I mentioned, if you've decided that you just don't feel you can accommodate people in jobs that are safety sensitive because there is no way to determine whether they are impaired or not, that may be an argument. But these are legal arguments and not, there are no answers. There's no easy answers anyway. Even just what is a safety sensitive role, for example, and how much is the individual using? Those are going to be different in every single case. And so for those of you who are in human resources, you may find this as something like the Americans with Disabilities Act reasonable accommodation process, which is every single time it's an individualized assessment and determination that gets made. It's not treating all people alike, quite the contrary.
Thank you. Another question that came in that deals directly with a certain type of employment is, what about school bus drivers in New Jersey? How are they impacted by what we've discussed today?
Well, that is an excellent question. And I am not familiar with any state drug testing law for school bus drivers. I don't know that there is one. I do know that if the bus is large enough, the school bus drivers are actually going to be subject to those Department of Transportation testing regulations, the federal law, and so they will be prohibited from using medical marijuana and even from using CBD creams and other things that might cause them to test positive. They'll be both medically disqualified if they choose to do that and let the medical examiner know, because they do have periodic medical exams, or if they test positive under the program. Now, something interesting that New York did about a year ago is they actually passed a law extending a drug testing and in fact random drug testing to school bus drivers, and they've defined school bus drivers quite narrowly to include, for example, minivans at smaller schools taking kids to and from sports activities or other, field trips and things like that. I don't think New Jersey has that, but I'm, again, not 100% familiar with the New Jersey laws on that topic.
Great. I have another question regarding CDL drivers, and it's from William Carmichael. And he asks, we have a mix of CDL drivers and non-CDL drivers. Clarify CDL requirements versus actions that can be taken against non-CDL, please.
Yes, certainly. So this is going to get really technical, William, so bear with me, but commercial motor vehicle drivers in the federal law, if you're covered by federal law, are individuals who operate vehicles that have either a gross vehicle weight rating of over 10,000 pounds, or they carry 8 or more passengers, or capable of carrying 8 or more passengers, right? So the number of seats in the vehicle, or any kind of, those are the two. Those individuals are subject to medical qualification standards, and those medical qualification standards prohibit the use of marijuana, okay? They're not, however, subject to drug and alcohol testing unless they also need a commercial driver's license. So these are typically larger passenger carrying vehicles, larger trucks, and anything at all, including your motorized bicycle, if it's placarded to carry any kind of hazardous materials. So if you have a commercial driver's license, you're subject to drug and alcohol testing under federal law, and marijuana is just say no, and if you test positive because you're a marijuana patient, you have violated those regulations. For the smaller vehicles, there's no mandatory federal testing, but as a medical qualification standard, marijuana use is still out. And we passed the slide on that, but there is one in there, and it'll be available later if you want to take a look at. I actually cited to that exact regulation where you can find that. Okay.
That's great. Alex Reiner asked a similar question, but it was specifically about non-CDL drivers who must drive for an 8-hour shift. So that his basic question was, what about employees being considered for those kinds of positions, which I think is something you just covered in that last question.
Well, a little bit, but I was talking still about trucks or larger trucks. Like, let's say you drive your own personal vehicle around to visit customers or potential customers. You're in a sales team, and you're out in the field by yourself. And the question is, what is the, can I turn that person away simply because, they are a medical marijuana user? And I don't have an answer for that. I can tell you that many employers would consider that to be a problem, knowing that the individual would be driving a vehicle in the course and scope of their employment with marijuana in their system, which, if impaired, right, and hard to know how much somebody will be impaired, would be a criminal violation of New Jersey law, right? So that is one of those close calls you will have to make. Is the individual, I would argue that person's going to drive for 8 hours, then you're not turning them away solely because they're a medical marijuana user, but because they are a medical marijuana user, as to whom driving is an essential job function. There may be other jobs where you are occasionally called upon to drive, or close in the city, where possibly a reasonable accommodation would allow those individuals to, when they needed to drive, take public transportation or call an Uber or something. And that might work out. So those are some things, some examples of how to, analyze how would you accommodate or how would you fit this individual's medical marijuana use into your workplace in a way that didn't compromise safety. Lots of ideas, no clear answers.
And I have another question, and this deals with notification that you spoke about in the beginning of the presentation. And you said that once the employer gave notification to the employee had 3 days to respond. Well, this question asks, does pre-employment law now require written notice to the future employee?
Yes. Anyone who tests positive for medical marijuana should be given written notice of their right to submit that certification or other legitimate use of marijuana, any medical use that they can have, that they want. And frankly, they'll probably give you other explanations that they may have. Anyway, and then you take that information and do what you will with it. They can also order a confirmatory retest. And that is for any worker, both an employee or an applicant.
That's a lot to process, Nancy, and it was very informative. I thank you for, quite frankly, an eye-opening presentation for all of our participants today. I believe Angelo would like to say a few words in closing. Angelo Valente, Executive Director of Partnership for Drug-Free New Jersey, please speak if you're on the line.
Sure. Thank you, Greg, and thank you, Nancy. We want to first and foremost thank Nancy for providing some very important information, as well as providing us with an opportunity to be able to explore a little deeper on some of these very complex issues, which we have learned still we don't have all the specific answers for, but certainly we are in the process of trying to be able to obtain those. I do also want to thank each of you for participating in this webinar. And as I mentioned earlier, we hope to be able to continue to provide these kind of opportunities for those members of Drugs Don't Work in New Jersey as a way to be able to keep everyone updated and have most current information on issues that will affect maintaining and managing a drug-free workplace. So once again, thank you all, and we look forward to continuing to provide these opportunities in the future.
I'm sorry, just one last question came in. If we could just address one last question from Scott Phillips. He asks, can an employee be suspended without pay while waiting the 3 days and additional test results?
Boy, that's an interesting question. Can they be suspended without pay? I think, if they're being suspended without pay and they're a medical marijuana user, there is an argument, right? If they're excused or they should be excused, there's an argument that would be you know, an adverse action in terms of the amount of, you know, they're not getting paid as much. One suggestion I have seen is that a lot of employers will perhaps suspend without pay, but then pay back the individual for missed work time if the test comes back excused. That's a little bit of a employer decision on how to do that, though. For some, just the payroll situation would be too complicated and they would just pay it anyway. So that is something that you could consider doing. But I would certainly suggest that if you wish to suspend someone without pay, that you have a back-end way to make it right fairly promptly if the test turns out, in fact, to be excused. And I didn't put in a plug for this, but there are lawyers all over New Jersey, including in the Littler Newark office, who are happy to help with employment law questions. And I know that some of the other lawyers who work with this group have suggested that until more is clear, you know, I can't do this, right? I'm not admitted in New Jersey. I can offer general advice here, but I do think that when you are faced with some of these thorny questions, you might want to talk to employment law counsel as you revise and update your policies.